In this episode, I would like to discuss about Section 9 of the Hindu Marriage Act 1955, which deals with the restitution of the conjugal rights. Very important section. The section says that if either spouse has withdrawn from the society of the other without any reasonable excuse, then the other spouse can make an application before the court of law for seeking the order of restitution of the conjugal rights. Now, what are the conditions are to be satisfied for granting the relief? That is the subject matter of discussions today. And also the means whether restitution of the conjugal rights order given by the court, it is violative of our constitution of India. That is also the related topic of today's matter. The concept of restitution of conjugal rights originated from the Jewish law, and from there it was adapted in English common law, and from English common law it came into practice in Indian judiciary system. So, restitution of the conjugal rights section 9 and its constitutional validity is subject matter of discussion today. Section 9 of the Hindu Marriage Act 1955 deals with the restitution of the conjugal rights. The section says that if either husband or wife or any of the spouse has without reasonable excuse has withdrawn from the society of the other spouse can make an application for restitution of the conjugal rights before the district court. And the district court, if satisfied that there is the truth of the statements in the petition and that there is no legal ground why the application should not be granted, the court will grant the relief. So, section 9 of the Hindu Marriage Act, there are various ingredients. Now, I am discussing, have a look, that section 9 of the Hindu Marriage Act, restitution of the conjugal rights, what are the essential ingredients? That either spouse has withdrawn from the society of the other without reasonable excuse, and application is to be made to the district court. So, district court is the competent jurisdiction, having competent jurisdiction to deal with the matter, and court is satisfied with the truth of the statements. So, this point, that court is satisfied with the truth of the statements, it is emphasizing upon the proof that there is the genuine reason that the application is based upon the reasonable grounds. It is not made frivolously or in order to misguide the court or for any other reasons. Now, fifth point is, if the court considered that there is no legal ground of rejection, if the court considers that there is no ground to reject the application, this section relates with section 23 of the Act, section 23 of the Hindu Marriage Act itself, so that before granting any relief under the Hindu Marriage Act, court is to satisfy itself that the petitioner is not making any attempt to the relief by his own misdeeds. That means he is not taking some unfair advantage while making the application, and that is why court will consider that no petitioner should be allowed to take the advantage of his own misdeed. And next point is that if the court is satisfied, then court will grant the decree. And last is the burden of proving reasonable excuse on the person who has withdrawn from the society. The person who has withdrawn from the society of the other, burden of proof as per the Indian Evidence Act, it is on the person who has withdrawn from the society of the other. So, these ingredients are very important in order to satisfy the restitution of the conjugal rights. So, if these criteria are fulfilled, only then court will grant the order of restitution of the conjugal rights. So, that means either spouse has withdrawn from the society of the other, there must be the reasonable excuse and the application to be made to the district court, and the court is satisfied about the truth, and there is no legal ground why the application should not be allowed, and ultimately the burden of proof is on the person who has withdrawn from the society of the other. Now, I would like to discuss about the first ingredient of section 9, that is, if either spouse has withdrawn from the society of the other. So, what does it mean by the word withdrawn from the society? It means that a mental process besides the physical process. So, a mental element is involved with it. It means that either spouse is not staying with the other spouse, or he or she is denying having the sexual intercourse, or not residing with the other spouse. So, it involves a mental process besides the physical separation. So, first ingredient is this, that either spouse is not staying with the other, or not performing the matrimonial duties, or denying to have sexual intercourse with the other spouse. So, these are coming within the purview of the withdrawal from the society. Section 9 of the Hindu Marriage Act, it deals with withdrawal from the society, whereas in judicial separation under section 10 or divorce under section 13, the word are used desertion. So, what is the difference between desertion and withdrawal from the society? So, in case of desertion, it means the permanent living, at least living by the one spouse against the other, whereas in case of restitution of the conjugal rights, withdrawal from the society, the living intention is permanently. If any spouse is living temporarily for a short duration, that either the wife has gone to the in-laws house for a short duration, it is not coming within the purview that withdrawal from the society. So, intention to withdraw should be in the nature of having some permanency, but desertion means it is completely left the other spouse. That is why in section 10 and section 13 the word has used that desertion, if either spouse has deserted, that means completely left and staying in other place. So, desertion always that one spouse has entirely left the other spouse and residing in some other area, that means they are not residing under the same roof. So, desertion is not possible if the spouses are residing under the same roof, that means they are already in the two different places, in two different houses they are staying. But withdrawal from the society is very much possible under the same roof. Under the same roof both spouses are residing, but one is denying from performing the matrimonial duties, one is denying to have the sexual intercourse with the other. These are all the kind of withdrawal from the society. Let us have a look at first ingredient, that is withdrawal from the society means failure to render the conjugal duties, second refusal to stay together, and third refusal to marital intercourse. So, these three, either of the conditions will tantamount to, that is withdrawal from the society, failure to render the conjugal duties, refusal to stay together, or refusal to marital intercourse. But there is difference with desertion, because desertion means complete living. So, these are the foremost ingredients that withdrawal from the society of the other as prescribed in section 9. Now, I will come to the next ingredient, that is without any reasonable excuse. Now, I would like to discuss about the second ingredient of section 9, that is without any reasonable excuse. Now, what does it mean by the term reasonable excuse? It cannot be put into any particular formula. It depends upon the factual matrix of the case. That means reasonable excuse is to be considered from the various facts and circumstances of the instant case. Now, in one case the factual matrix can be differ from the factual matrix on facts and circumstances of the other case. So, reasonable excuse, it is distinguished from the various kinds of matrimonial offences, or there may be the difference of form in case of reasonable excuse and the various forms under the divorce, judicial separation, or nullity of the marriage. So, what are the reasons for nullity of the marriage or divorce or judicial separation? Reasonable excuse cannot be also based upon the any of the form. It can be in nature completely different from either of the matrimonial offence or the various forms of the proceedings, either under section 10 judicial separation or 13 or divorce or nullity of the marriage according to section 11, etc. So, let us have a look that reasonable excuse, it is differed from matrimonial offences, form of ground of nullity of marriage, judicial separation or divorce. Nullity of marriage, we know that is of section 11, or judicial separation, that is means section 10, and divorce, that is section 13. So, reasonable excuse, it is depending upon the circumstances, facts and circumstances of the instant case. Court will determine whether the withdrawal made by one spouse, there is the sufficient reason or not. Now, I would like to discuss about one prominent judgment of Delhi High Court, that is Ashok versus Sabnam. It was decided that if any wife who is compelled to leave the matrimonial home because of constant demand of dowry, it will be considered as reasonable excuse. So, let us have a look that reasonable excuse, in this case Ashok versus Sabnam 1989 Delhi, it was decided that if the wife is compelled to leave the matrimonial home because of the constant demand of the dowry, it is coming within the purview of the reasonable excuse. So, actually reasonable excuse, following the various English decisions, our courts are also on the view that reasonable excuse must be something grave, weighty and convincing in nature. So, this judgment is very much relevant about the concept of reasonable excuse. Now, I would like to discuss about Order 21 of Code of Civil Procedure and two relevant rule, that is Rule 32 and 33 of the Code of Civil Procedure. Now, Order 21, that is execution of the decree under the Code of Civil Procedure 1908, and Rule 32 of it states about that court has the power to execute the order of the restitution of the conjugal rights. How it can enforce that? It says Rule 32 that if any party, that means either spouse, husband or wife, after the order of restitution of the conjugal rights is passed by the court, if he is willfully disobeying it, he is not complying with the order of the restitution of the conjugal rights, by virtue of Rule 32 of Order 21 of the Code of Civil Procedure, court has the power to attach the property of that person. Court cannot arrest him, but attachment is prescribed. And in Rule 33, it is stated the discretionary power of the court for enforcement of the order of the restitution of conjugal rights. Here court can exercise the financial coercion in order to compel the other spouse to comply the order. So, the order can be much more harsh in this way. So, Order 21, Rule 33 deals with the coercion power of the court in order to enforce the order. Now, let us have a look that Order 21 of the Civil Procedure Code 1908 deals with execution of decrees and orders. Rule 32, decree for specific performance for restitution of the conjugal rights or for injunction, and Rule 33, discretion of court in executing decree for restitution of the conjugal rights. So, by virtue of these two Rule 32 and Rule 33 of Order 21 of the Civil Procedure Code 1908, court has such power to enforce the order of the restitution of the conjugal rights, and court can vary it in order to frighten the spouse so that the order can be complied properly. Finally, I would like to discuss about the constitutional validity of section 9 of the Hindu Marriage Act. That means whether the order given by the court of restitution of the conjugal rights, it is violative of Article 21 of the Constitution, that is on the ground of that it violates the right of privacy and dignity, because it compels one person to stay with the other spouse without his consent. He is not willing to stay with the other spouse, but by virtue of section 9 she or he is constrained to stay with the other. So, whether it is violative of Article 21 on the ground that it is against the right of privacy and against the human dignity. So, let me consider three judgments in this aspect. Now, first is that T. Sarita versus T. Venkata Subaiya. T. Sarita versus T. Venkata Subai in the means AIR 1983, it is Andhra Pradesh High Court judgment. It is stated there, it is observed by High Court of Andhra Pradesh that it is violative of the Constitution Article 21, because it is against the right of privacy and against the human dignity. But later on it was strongly criticized in other judgment, that is Harvinder Kaur versus Harminder Singh. It was strongly criticized in that judgment, but ultimately Supreme Court in another judgment, that is Saroj Rani versus Sudarshan in the year 1984 AIR. In Saroj Rani versus Sudarshan, it was decided by the apex court that no, it is not violative of the Article 21 of the Constitution, because aim of the section 9 of the Hindu Marriage Act is to provide the opportunity to the parties so that they can live in amity, because it is made for the means cohabitation and consortium of the parties. It is not, marriage is not made for sexual gratification only. It is the aim of the section 9 is this, that so that the cohabitation and consortium between the spouses can be achieved and that they can reside into the matrimonial home in amity. So, let us have a look that constitutional validity of section 9. So, first whether section 9 is violative of Article 21 of the Constitution or not. Now, cases I have discussed three cases. Case 1, that T. Sarita versus T. Venkata Subai, it was decided by Andhra Pradesh High Court that it is violative of Article 21, and it was strongly criticized by Harvinder Kaur versus Harvinder Singh case, but ultimately it was overruled. The decision of Sarita is overruled by the case of Saroj Rani versus Sudarshan by our apex court. Supreme Court stated that it is not violative of the Article 21 of the Constitution, so it is valid. So, this is the elaborate discussions of section 9 of the Hindu Marriage Act, and it is constitutional, there is nothing unconstitutional. So, the section is valid.